Firstly, we shall examine Tony's case, and this case revolves around the tort of negligence, which commenced from Donahue versus Stevenson, and provides a remedy in the form of damages where an injury or loss is caused to the injured party because of the wrongdoer's fault to take reasonable care. The central issue is whether there was a misfeasance or a non-feasance on the part of the BBC, and whether there was a breach of a legal duty, i.e. not sweeping the floor after the repair works. The four elements that need to be present to satisfy and prove that the BBC have been negligent are actionable damage, a breach of a duty of care, a breach of this duty, and causation. Firstly, there is actionable damage, as Tony has suffered damage to both eyes and has been diagnosed with sympathetic ophthalmia. This is supported by the Limitation Act 1980, Section 38, subsection 1, which mentions personal injuries, including any diseases or impairments of a person's mental or physical condition, and construed accordingly. There's also more damage than just a minimal triviality, as established by Rothwell, because there are severe damages that have rendered Tony unable to work. The next issue is to determine whether there was a duty of care owed by the BBC. Usually this would be done by the Caparo test, which would have reasonable foreseeability, proximity, and whether it would be fair, just, and reasonable to award damages. However, in this case, using the precedent found in Barrett versus Ministry of Defence 1995, it can be established that since the BBC are the employers, they assume responsibility for ensuring the proper cleaning of their premises to make it safe for their employees. Since the BBC have committed a non-feasance, aka an omission, because they failed to sweep the floor. Normally there would not be damages available for omissions, however there are exceptions, such as in Littlewood and Smith, where it was established that generally there aren't any remedies available, but if there's a special relationship, there can be a remedy. This was also supported by Dorset Yacht versus the Home Office in 1970. Moreover, the Health and Safety Act 1974 suggests that as an employer, the BBC has a duty of care towards its employees to ensure their safety. The principle of vicarious liability also applies, suggesting that due to the employer-employee relationship, that the tort committed must be closely linked with the nature of that relationship. Hence, if the stagehands were employed by the BBC, then they owe a duty of care towards Tony. Hence, it can be established that the BBC owed Tony a duty of care. Moving on to the breach of duty, a breach can be proven as set out in Nettleship v Weston in 1971, as the BBC fell below the objective standard of care that is required, as they failed to ensure that the stage was swept. Section 7 of the Health and Safety Act 1974 also sets out that employees are responsible for their own and others' safety. Hence, there's been a breach of duty here. Moving on to causation. Firstly, factual causation can be proven by the but-for test, and had the stage been adequately cleaned, the stone would not have caused Tony's injury. Hence, there is liability. This test was set out in Barnett v Chelsea, and the burden of proof on Tony is satisfied because it has directly caused the harm he has suffered. Moving on to legal causation. Legal causation is obviously split into two distinct categories, remoteness and intervening acts, and insofar as remoteness is concerned, the Wagon Mound case decided that if at the time of a breach it was reasonably foreseeable that damage was not too remote, then there is then remoteness is satisfied. In terms of intervening acts, they would follow the same route in terms of actionable damage. However, because of Dr. Riff. However, because the Caparo test doesn't apply, because there's a special relationship between the doctor and the patient, the test is whether there was true consent, and this was set out in Chester v Afshar, where there was no consent and the doctor was found liable. The Montgomery test in 2015 has replaced the Bolam test in 1957, as there's been a worsening since the eye drops were prescribed to Tony. However, as in Dorset Yacht 1970, if a doctor was to perform a surgery or commit any medical procedure, then this does not break the chain in causation. Moreover, in Robinson v Post Office 1974, despite the doctor's breach, the judges found that if it was the original employer's fault, through successive causes, as in Baker v Willoughby, the original defendant is still liable for all successive harms, and it does not break the chain of causation. And furthermore, under policy considerations, judges would find it extremely difficult to find doctors liable for damages and for the consequential economic loss that Tony suffered. Hence, I believe that the BBC would be liable for the harm and the consequential economic loss, as Tony is now unable to work. Moving on to Maria, the damages that Maria suffered is a type of cancer called mesomeloma, and here the issue revolves around whether the BBC committed an act or an omission, and that is determined through the Caparo test. Is it the BBC's duty to wash the clothing or to stop the transmission of asbestos? This was discussed in Carey v Vauxhall Motors. Now, the BBC can argue, in terms of an omission, they can evade liability, as they had no special relationship with Maria. As aforementioned, omissions do not carry the weight of liability, and therefore they would not have to pay damages to Maria. This would most likely be the case because of a public policy consideration in which judges would not extend the burden from employers onto the employees' families, because it would stretch the law too broadly. And therefore they would be reluctant to compensate Maria. And this was discussed in Vauxhall, but I believe that if it is an act, which it is, I believe, then the route of liability and payment of damages would be significantly different because of a duty of care. And a duty of care can be established without needing to prove a special relationship, simply by looking at the criteria set out in the Caparo test. Firstly, there was reasonable foreseeability. This is because Bernardo had worked there for a period of 20 years. There is ample precedent through the Maguire versus Harland-Wolff case to suggest that there is enough expert literature out there detailing the risks of asbestos transmission and secondary exposure. Hence, the claim would be valid. In terms of proximity, because of the scientific knowledge and the literature available to the company during Bernardo's working there, there should be damages available. The Scottish authority of Babcock can be used here, as judges ruled in favour of the claimant. Moving on, in terms of whether it is fair, just and reasonable to award damages, it is good consideration to make that the judges would consider these types of cases because the claimant is the innocent party, and they had no direct link to the company. They just cared for their partner. Hence, I believe that judges will award these claims, such as in Vauxhall. In moving on to breach, this duty can said to have been breached because, following Latimer versus AEC, it is expected that an employer should use a standard and reasonable precaution to protect their employees. The BBC have not acted in such a way. They've acted in contrast and fallen below the standard of care. And as such, the workplace has been proven to be full of asbestos, and they did not take any precaution in terms of cleaning the overalls. Hence, they failed to ensure that the asbestos wasn't transmitted. Furthermore, moving on to causation, factual causation is firstly determined by the but-for test and the balance of probabilities. However, the but-for test doesn't apply here because Bernardo worked both for the LBC and the BBC. Hence, the question would arise of who has exposed Maria to the asbestos. Under the McGee case, the principle of a material increase of risk is what will be used to determine the liability of the BBC. Even through the Barker case in 2006, liability is said to be a portion of the total risk. However, using the Fairchild exception, Maria can claim all compensation from the BBC, which can be split into joint and several liability between both the LBC and the BBC, supported by the Compensation Act, Section 3. In terms of legal causation is determined by remoteness and intervening acts, and as argued before, it is not too remote to argue that there was reasonable foreseeability in the tort committed by the BBC, as there's ample evidence. In terms of an intervening act, there does not seem to be a break in the chain of causation because Maria has not done anything out of the blue. Hence, in conclusion, I believe that the BBC will be jointly and severally liable for Maria's claims and also liable to award damages for Tony.